This could be the end of Apple as we know it. 16 states and the U.S. Department of Justice have sued Apple, claiming the company has monopolized or attempted to monopolize the entire smartphone market. Now, just 2 years ago, 124.7 million people used Apple iPhones, and that number is surely to have only grown here in the U.S. So, what does the DOJ's antitrust lawsuit mean for the iPhone that's in your hand right now? To fully understand the DOJ's lawsuit, you have to understand the law that it's brought under, which would be the Sherman Antitrust Act of 1890. I don't want to overcomplicate this. The Sherman Act broadly prohibits, number one, anti-competitive agreements, and then number two, unilateral conduct that monopolizes or attempts to monopolize the relevant market. So you don't have to have an agreement with your opponent to violate Section 2. The Act authorizes the DOJ to bring lawsuits to prevent conduct violating the Act, and additionally authorizes private parties injured by conduct violating the Act to bring suits for something called treble damages, which is 3 times as much money in damages as the violation actually cost you. Private parties who can successfully prosecute an antitrust case can make so much money. I mean, it's kind of insane. Antitrust cases can bring defendant companies to their knees. Sometimes. In the past 130 years, courts have had to rule on lots and lots of Sherman Antitrust Act cases. And as a result, there are now basically case-made rules that provide that certain types of anti-competitive conduct is per se illegal, meaning that if you can prove the conduct, you win. You skip straight to the finish line and you get that money. But for most other types of conduct, there's an argument to be made on both sides as to whether the conduct is unreasonably restrictive of trade. And this case-by-case analysis is great for lawyers because of billing. The purpose of the Sherman Antitrust Act is not to protect competitors from harm from legitimately successful businesses, nor to prevent businesses from gaining honest profits from consumers, but instead it's to preserve a competitive marketplace to protect consumers, that's you and me, from abuses. That's as basic as you're gonna get. And I'm sure you already know all this. I mean, it's kind of right there in the name. And if you liked U.S. history as a kid, you know that the law was passed to rein in the robber barons of that era. Your Rockefellers, Vanderbilts, Carnegie, I don't know. They have a music hall. And other companies like that. That was a long time ago. I was a kid in 1890. Surely those problems have gone away, right? Well, yes, but in its place, we have these tech titans like Google, Microsoft, IBM, Apple, and others. And almost all of these have gotten so big that the DOJ has at one time or another tried to, trim them back with Sherman cases. And sometimes it works, and sometimes it doesn't. But the stakes for Apple today are very, very high. Since the announcement of the lawsuit, the Apple share price is down about $6. Now, that may not seem like very much money to you, especially if you've recently bought a coffee from Starbucks. But the company is so large that the price reduction equates to about $90 billion in total company value. And surely that is a lot to you. The lawsuit alleges that Apple violates Section 2 of the Sherman Antitrust Act specifically. Section 2 is short. It simply states, every person who shall monopolize or attempt to monopolize or combine or conspire with any other person or persons to monopolize any part of the trade or commerce among the several states or with foreign nations shall be deemed guilty of a felony, and on conviction thereof shall be punished by a fine not exceeding $100 million if a corporation, wow, or if any other person, $1 million, or by imprisonment not exceeding 10 years, or by both of said punishments, in the discretion of the court. That's actually how people talked in 1890. That's what the law says. I've said this before in other videos regarding the DOJ indictments and lawsuits. Although they usually have been criminal, and this is a civil lawsuit, the DOJ doesn't tend to file a lawsuit unless they believe that they can win. And in this 88-page lawsuit, they offer 5 specific technologies that Apple has allegedly suppressed that would have increased competition in the smartphone industry. Those technologies being super apps, cloud streaming games, messaging apps, smartwatches, and digital wallets. All kinds of technology that should allow a consumer versatility in switching between products, but according to the DOJ, Apple has instead chosen to restrict access to maintain or grow their market share. The lawsuit claims that there are 2 main ways that Apple restricted innovation: control of app distribution or control of application programming interfaces by denying access to key points of connection between apps and the iPhone's operating system. In total, the lawsuit alleges 6 violations by Apple, 2 of which are in the alternative. Here's the basic thrust of the lawsuit. It's actually a quote from page 3 of the lawsuit that tells the real story behind the DOJ's mission. Listen to this. Apple's conduct also stifles new paradigms that threaten Apple's smartphone dominance, including the cloud, which could make it easier for users to enjoy high-end functionality on a lower-priced smartphone, make users device agnostic altogether. As one Apple manager recently observed, imagine buying an expletive Android for $25 at a garage sale and it works fine. And you could have a solid cloud computing device. Imagine how many cases like that there are. Simply put, Apple feared the disintermediation of its iPhone platform and undertook a course of conduct that locked in users and developers while protecting its profits. Critically, Apple's anti-competitive conduct not only limits competition in the smartphone market, but also reverberates through the industries that are affected by these restrictions, including financial services, fitness, gaming, social media, news media, entertainment, and more. Unless Apple's anti-competitive and exclusionary conduct is stopped, it will likely extend and entrench its iPhone monopoly to other markets and parts of the economy. For example, Apple is rapidly expanding its influence and growing its power in the automotive, content creation and entertainment, and financial services industries, and often by doing so in exclusionary ways that further reinforce and deepen the competitive moat around the iPhone. This case is about freeing the smartphone markets from Apple's anti-competitive and exclusionary conduct and restoring competition to lower smartphone prices for consumers, reducing fees for developers, and preserving innovation for the future. That is what they're saying this case is about. It sounds to me like the DOJ doesn't get it. It actually sounds like a Marxist term paper from a college sophomore. They think that Apple owns the smartphone market, but look around you. Look what's in people's hands. It's not even close. But more on that in a minute. In paragraph 202 of the lawsuit, it actually has a lot more paragraphs than that even. The DOJ really puts all of its cards on the table when it says that Apple's anti-competitive acts include, but are not limited to, its contractual restrictions against app creation, distribution, and access that have impeded apps and technologies, including but not limited to super apps, cloud streaming, messaging, wearables, and digital wallets. The areas identified in this complaint reflect a non-exhaustive list of recent anti-competitive acts, but as technology advances, both the technologies impeded and the specific manner of impediment may shift in response to technological and regulatory change consistent with Apple's past conduct. The DOJ is saying that we know they're going to keep doing this if we don't stop them. In a nutshell, this is what all tech companies are doing all the time. And I don't want to say that nothing will come of this lawsuit, but Apple's business is not the devices. It's the two-sided marketplace that it has created for creators and users of technology. And the idea that Apple has created a monopoly is a little nuts. There are people who don't visit their marketplace at all. There's other phones, smartwatches, computers, streaming services, and so on. I mean, if this were 2010, I'd say they're doing a pretty good job of trying to create a monopoly, but it didn't work. It's not even a duopoly. There's lots of options out there, everywhere, for everything, all the time. Some consumers just don't want the ecosystem. They don't want it at all. And then some people, like me, just want, bits and pieces of it, not all of it. Like even the watch, for example. Oh, also have some of these. In the end, talented lawyers from the DOJ are going to spend several years of their career working this case, and antitrust lawyers hired by Apple are going to do the same thing. And there will be a lot of facts that are good and bad for the case, and some strong legal theories and indications of guilt, and some weaknesses and good defenses. And all in all, it's going to cost Apple hundreds of millions of dollars in legal fees, maybe billions, actually. And then a settlement will be reached. And as crazy as it sounds, the legal fees themselves may be the biggest fine or punishment that Apple suffers. And then they'll agree to pay like a $800 million fine or $50 million fine, and that'll be the end of it. Apple, unsurprisingly, denies everything, stating that the lawsuit threatens who we are and the principles that set Apple products apart in fiercely competitive markets, as well as promising to vigorously defend against it. But that's Apple. What do you think? Do you believe Apple has a monopoly in the smartphone market? Do you not give a because you own an Android? Drop your pro se opinion down below in the comments and let me know what you think. Oh, and also, I just texted you something. claiming the company and successfully bring an antitrust case. DJ Garland in the house.